I was standing in my driveway on a Tuesday morning in June when I noticed the first orange cone blocking the entrance to what had always been my private road. The gravel lane stretched from the main highway back through a quarter-mile of oak trees before forking into driveways serving my property and my neighbor's cabin. For 32 years, that road had been mine, maintained by me, plowed by me in the Colorado winters, and used exclusively by myself and old Tom Henderson, who lived at the far end. But apparently, someone had different ideas. A woman I had never seen before was directing a landscaping crew to set up more cones along the entire length of the road. She wore white capri pants despite the dust, oversized sunglasses, and carried a clipboard like it was a weapon. Her blonde hair was cut in that distinctive speak to the manager style that immediately put me on alert. "Excuse me," I called out, walking toward her. "What's going on here?" She looked up from her clipboard with an expression of practiced patience, the kind reserved for explaining simple concepts to people she considered beneath her. "Good morning. I'm Brenda Patterson, president of the Riverbend Acres Homeowners Association. We're preparing to repave this public access road as part of our community improvement initiative." My jaw tightened. "Public access road? This is a private road. It's on my property." Brenda's smile didn't waver, but her eyes turned cold. "I'm afraid you're mistaken, Mr. Lawson." "Lucas Lawson. And I'm not mistaken. I've owned this property since 1994, and the road has been private since long before that." "Well, Mr. Lawson, according to the county records and our legal team, this road provides necessary access to the development behind your property and has been designated as a public thoroughfare. We'll be installing speed bumps, proper lighting, and eventually sidewalks to ensure the safety of our residents." I stared at her. "What development? There's nothing behind my property except Tom Henderson's cabin and about 500 acres of national forest." "Not anymore," she said, her voice dripping with satisfaction. "Riverbend Acres is a new planned community of 47 homes currently under construction. The first families moved in last month. This road is the primary access point as designated in our HOA charter and approved by the County Planning Commission." My heart started pounding. Nobody contacted me about any of this. The HOA sent notification letters to all affected property owners in March. "Perhaps you should check your mail more carefully." She turned back to her crew. "Miguel, let's get those cones extended all the way to the highway." I pulled out my phone and called my neighbor. Tom answered on the third ring, his gravelly voice thick with confusion. "Lucas, you seeing what I'm seeing out there?" "Yeah. Did you get any letters from an HOA? Got something in March. Thought it was junk mail. They claimed my cabin was now part of some association and I owed them dues. I threw it away. They're saying the road is public now." Tom let out a stream of curses colorful enough to make a sailor blush. "The hell it is. Your grandfather built that road in the 50s. I got pictures somewhere. That sparked something in my memory. Tom, remember when my dad passed and we went through all those old documents? Where did we put that stuff? Should be in your barn, in those filing cabinets we moved from the main house." I thanked him and headed straight for the barn, my mind racing. The property had been in my family since my grandfather, Lawrence Whitman, purchased it in 1952. He'd built the original house, the barn, and carved out the road himself using a borrowed bulldozer and sheer determination. My father had inherited it, expanded the house, and I'd received it after his death in 1993. The road had always been private, maintained at family expense, and there had never been any question about ownership. The barn was hot and dusty, smelling of old hay and motor oil. The filing cabinet stood against the back wall, exactly where we'd left them years ago. I yanked open the top drawer of the first cabinet and started digging through manila folders thick with age. Tax records, receipts, correspondence, photos. The second drawer held more of the same. The third cabinet was different. These were the really old documents, some dating back to before Colorado was even a state. My grandfather had been meticulous about keeping records, and he'd inherited a bunch of papers from the previous owner when he bought the land. I found the deed about halfway through the second drawer. The paper was heavy, cream-colored, and covered in elegant handwriting that had faded to brown. The date at the top read July 15, 1891. According to this document, a man named Ezekiel Morrison had purchased 320 acres from the United States government under the Homestead Act. The property description matched my current lot perfectly, right down to the creek that formed the eastern boundary. And there, in careful script, was a specific clause, including all roads, paths, and thoroughfares constructed upon or across said property, to remain private and for the exclusive use of the landowner and designated parties in perpetuity. I pulled out my phone and took a dozen photos of every page. Then I kept digging. I found my grandfather's deed from 1952, my father's inheritance papers from 1979, and my own deed from 1994. Each one referenced the property's boundaries and included language about the private road. I photographed everything. By the time I emerged from the barn, it was past noon and the landscaping crew had vanished. The orange cones remained, lining the road like a hostile invasion. I drove into town, specifically to Durango, where I'd lived my entire life. I needed a lawyer, and I needed one who understood property law. Martha Hendricks had an office above the hardware store on Main Street. She'd handled my father's estate and various property issues over the years. Her secretary, a young guy with impressive facial hair, told me Martha was with a client but could see me in 20 minutes. I waited, scrolling through the photos on my phone and getting angrier by the minute. Martha was in her 60s, built like a bulldog, and had a reputation for being absolutely ruthless in court. When she called me back to her office, I didn't waste time with pleasantries. An HOA is claiming my road is public property. They want to repave it, add speed bumps, and turn it into the main access for some development I knew nothing about. Martha leaned back in her chair. Riverbend Acres. You know about it. Everyone in the county clerk's office knows about it. The developer, some outfit from Denver called Summit Properties, pushed through approvals faster than anyone's ever seen. There were some questions about proper notification procedures, but the Planning Commission approved it anyway. 47-lot subdivision, all sold before construction even finished. They're claiming my road is public. Is it? I pulled out my phone and showed her the photos. Martha put on her reading glasses and studied each image carefully. Her expression shifted from professional interest to something approaching glee. Lucas, do you know what you have here? An old deed. A deed that predates the county's incorporation by 3 years. A deed with explicit language about road ownership that's been consistently maintained through every subsequent transfer. This is beautiful. She looked up at me. Do you have the originals in my barn? Get them. Put them in a safe deposit box today. Then I need you to write down everything that happened this morning, everyone you spoke to, exactly what was said. I'm going to file for an emergency restraining order to stop any work on that road until we can sort this out. Can they really just claim my road is public? Martha shook her head. Not legally. But what they're probably counting on is that you won't fight back. Most people don't. They see official-looking letters and county stamps and they assume someone in authority approved it all properly. But property rights are serious business, especially in Colorado. If that road has been private since 1891 and you can document continuous private ownership, the HOA doesn't have a leg to stand on. So what happens now? Now we make their lives very difficult. I'll need a retainer of $5,000 to start. This is going to get messy. I wrote the check, feeling both relieved and anxious. $5,000 was a lot of money, but losing my property rights was unacceptable. Martha promised to have the restraining order filed by end of business and told me to expect contact from the HOA's lawyers within a few days. I spent the rest of the afternoon securing the original deeds in a safe deposit box at the bank and writing out everything I could remember about my conversation with Brenda Patterson. That evening, I drove back out to my property to find a citation tucked under my windshield wiper. The citation, printed on official-looking letterhead, informed me that I was in violation of Riverbend Acres HOA regulations by parking a vehicle on a public access road. Fine, $200. Payment due within 14 days. I called Martha immediately. She answered on the second ring, sounding amused. Let me guess, they cited you for something. Parking on a public road, how did you know? Because it's straight out of the aggressive HOA playbook. They're trying to establish precedent and authority. Ignore it, don't pay a cent. In fact, send me a photo of the citation. It'll help our case. The next morning, I woke up to find a truck from a fencing company unloading materials at the entrance to my road. 2 workers were measuring and marking positions for fence posts. I pulled on jeans and boots and headed out to confront them. Morning, I said, keeping my voice level. What's the fence for? The older worker, a guy in his 50s with a weathered face, shrugged. We just go where they tell us. HOA hired us to fence off this road. Something about controlling access. You can't do that. This is private property. He pulled out a work order. Says here it's a public road maintained by the Riverbend Acres HOA. We got all the permits. Those permits are fraudulent. This is my property and that's my private road. If you install a fence, you'll be trespassing. The worker looked uncomfortable. Look, buddy, I don't want trouble. We're just doing a job. I understand. But I'm telling you officially, as the property owner, that you do not have permission to install anything on my land. My lawyer filed a restraining order yesterday. If you proceed, you'll be in violation of a court order. That got his attention. He pulled out his phone and called someone, walking far enough away that I couldn't hear the conversation. 5 minutes later, Brenda Patterson pulled up in a white Lexus SUV, her face flushed with anger. Mr. Lawson, you are interfering with authorized work on public property. I could have you arrested. Go ahead and try. This is private property and you have no authority here. The county has designated this as a public access road. We have documentation. So do I. Documentation that goes back to 1891. Want to compare dates? For the first time, Brenda looked uncertain. That's impossible. The HOA's legal team reviewed all the county records. Then your legal team missed something important. My lawyer is Martha Hendricks. Feel free to have your people call her. I turned to the fence workers. Gentlemen, I apologize for the confusion, but do not install any fence on this property. You'll be held liable for damages and trespassing. The older worker held up his hands. We're leaving. This is above our pay grade. Brenda watched them pack up, her face turning an impressive shade of red. This isn't over, Mr. Lawson. The HOA has resources and legal standing. You can't just block access to an entire community. I'm not blocking anything. There is no community behind my property. You built your development and you failed to secure proper access. That's not my problem. There are children who live back there. Emergency vehicles need to get through. If someone dies because you're being stubborn, their blood is on your hands. It was a low blow, and we both knew it. If access is such a critical issue, perhaps the developer should have ensured they had legal right-of-way before selling homes. Again, not my problem. This road is private and it stays private. Brenda got back in her Lexus and peeled out, spraying gravel. I watched her go, my hands shaking slightly from the adrenaline. This was escalating faster than I'd expected. Tom called me an hour later. "Lucas, you need to get up here." I drove the quarter-mile to his cabin and found him standing in his front yard, staring at a notice that had been nailed to his door. The notice, signed by Brenda Patterson, informed Tom that his cabin was not in compliance with HOA regulations regarding exterior appearance. He had 30 days to repaint in approved colors, remove all unauthorized structures including his woodshed and chicken coop, and bring his property up to code or face daily fines of $100. Tom was 78 years old and had lived in that cabin since 1967. "They can't do this, can they?" "No, your property isn't part of their HOA. You never signed any agreement with them." "That's what I figured, but Lucas, I don't need this stress. I'm too old for this nonsense." I put a hand on his shoulder. "Call Martha Hendricks. Tell her what happened. This is harassment, and it's going to stop." Over the next week, things got worse. The HOA placed a lien on my property for unpaid road maintenance fees totaling $8,000. They sent letters to the county claiming I was blocking emergency access. They even contacted the local newspaper, painting me as a selfish landowner putting lives at risk for no reason. The newspaper actually called me. A reporter named Jessica Chen wanted to hear my side of the story. I invited her out to the property and showed her everything. The original deed, the photographs, the documentation of continuous private ownership. I explained that I'd never been notified about the development, never approved any access, and had clear legal ownership of the road. Jessica was thorough, asking tough questions about emergency access and community needs. But she was also fair. When I showed her the timeline of events and the HOA's increasingly aggressive tactics, she took notes and promised to present both sides accurately. The article ran the following Sunday. The headline read, "Property rights dispute escalates between landowner and new HOA." Jessica had done her homework. She'd interviewed Brenda Patterson, who claimed the road had been public for decades. She talked to residents of Riverbend Acres, some of whom expressed concern about access issues while others admitted they'd assumed the developer had secured all necessary rights of way. And she'd presented my evidence, including references to the 1891 deed and the clear chain of private ownership. The article shifted public opinion. Comments on the newspaper's website ran about 60-40 in my favor, with many people questioning how the development had been approved without proper access verification. The County Planning Commission suddenly announced they were reviewing the Riverbend Acres approval process. Martha called me on Monday morning. "The HOA's lawyers want to meet. They're proposing an easement agreement." "What kind of agreement?" "They want to formally establish a public easement across your property for the road. In exchange, they'll drop all fines and liens, and they're offering $50,000 as a one-time payment." "No. Lucas, hear me out. $50,000 is real money, and fighting this in court could cost you more than that in legal fees." "I don't care. That road is mine. My grandfather built it. My family has maintained it for 70 years. I'm not selling off pieces of my property because some HOA screwed up their due diligence." Martha was quiet for a moment. "Okay, then we fight, but I need you to understand what that means. This will get expensive and ugly. The HOA has deep pockets from all those member dues. They can afford to drag this out." So I'll sell my truck if I have to. This is about principle. All right, I'll tell them no, but Lucas, be prepared. They're going to come at you hard. She wasn't kidding. 2 days later, I received a certified letter from the County Code Enforcement Office. Someone had filed a complaint about multiple violations on my property. Unpermitted structures, illegal dumping, failure to maintain fences, and improper storage of hazardous materials. An inspector would be visiting within the week to assess the situation. I knew exactly who had filed the complaint. Every single alleged violation was either false or grossly exaggerated. The unpermitted structures were a hay barn built in 1956 and grandfathered under every code. The illegal dumping was a compost pile. The fences were perfectly maintained. And the hazardous materials were a few cans of paint and motor oil stored properly in my garage. When the inspector arrived, a tired-looking man named Robert Chen, he seemed apologetic. "Mr. Lawson, I have to investigate every complaint we receive. Can we walk the property?" "Of course." I showed him everything. Robert took photos, made notes, and asked questions. At the end of the inspection, he shook his head. "This is clearly a frivolous complaint. Your property is in excellent condition. I'll file a report stating that no violations were found." For what it's worth, I'm sorry you had to deal with this. Can I ask who filed the complaint? The report says it was submitted anonymously through the HOA management company for Riverbend Acres. We're required to investigate regardless of source. After Robert left, I sat on my porch and tried to think strategically. The HOA was using every tool at their disposal to pressure me into giving up. They were counting on me getting tired, getting overwhelmed, or running out of money. But I had something they didn't: righteous anger and a stubborn streak inherited from 3 generations of Colorado landowners who didn't back down from fights. That evening, I decided to go on the offensive. I drove to the Riverbend Acres development to see exactly what I was dealing with. The entrance was marked by a fancy stone sign and landscaped gardens. Beyond that, paved streets wound through a neighborhood of large, modern homes on small lots. Everything was immaculate: perfect lawns, matching mailboxes, and decorative street lights. I followed the main road through the development. It curved around for about half a mile before ending at a cul-de-sac. There was no other exit. The only way in or out of Riverbend Acres was the road they claimed was public, my road. I parked and got out, walking around to get a feel for the place. A woman in her 30s was outside with 2 kids riding bikes. She waved tentatively. "Hi," I called out. "I'm Lucas Lawson. I own the property where your access road starts." Her expression changed immediately, becoming guarded. "Oh, you're the one causing all the trouble." "Actually, I'm the one being harassed by your HOA. Did you know that road is private property when you bought your house?" She frowned. "The realtor said the HOA maintained all common areas including roads. We pay monthly dues for that. Your HOA doesn't own that road. It's on my private property and always has been. The developer who sold you this house didn't have legal right to use it as access. But how else are we supposed to get to our homes? That's a question you should be asking your developer and your HOA, not me. I'm not the one who created this situation." I could see her processing this, worry creasing her face. "The HOA president said you were just being difficult, that you wanted money from us." "The HOA president is lying. I've never asked for a cent. I've asked them to stop trespassing on my property and respect my legal rights as a landowner. There's a difference." I gave her my phone number and told her to call if she wanted to see the documentation. Then I left, knowing I'd probably just made things more complicated, but feeling like the residents deserved to know the truth. That night, my phone started ringing. First it was the woman I'd talked to, Ashley, who apologized and said she wanted to see the deeds. Then it was her neighbor, Mark, who was furious that the HOA might have misled them. Then a few more residents, all asking questions and expressing concern. By the end of the week, there was a civil war brewing inside Riverbend Acres. About half the residents believed Brenda Patterson's claims that I was just being greedy. The other half had started asking uncomfortable questions about the development's legal status and whether the HOA had exposed them to liability. The breaking point came at the monthly HOA meeting. I wasn't invited, obviously, but Mark called me afterward and filled me in. Brenda had stood up and assured everyone that the HOA's legal position was solid, that the road was definitely public, and that I would either surrender or be forced to by the courts. When Mark asked to see the documentation proving this, Brenda had refused, citing attorney-client privilege. When another resident asked why the developer hadn't secured an easement before selling homes, Brenda had deflected and changed the subject. The meeting had devolved into shouting. A faction of homeowners demanded that the HOA open its books and show them exactly what legal basis they had for claiming road ownership. Another faction accused the questioners of siding with me against their own community. It ended with no resolution and a lot of angry people. 3 days later, I received a formal lawsuit. The Riverbend Acres Homeowners Association was suing me for declaratory judgment to establish the road as a public right-of-way, plus damages for interfering with their property rights and causing emotional distress to residents. Martha reviewed the lawsuit and actually laughed. This is weak. They're claiming adverse possession and implied easement, but they can't possibly meet the legal requirements. They've only existed for a few months. Adverse possession requires continuous use for 18 years in Colorado. An implied easement doesn't apply when there's clear documentation of private ownership. So we can win this, absolutely. But it's going to take time and money, court dates, depositions, expert witnesses. We're looking at 6 months minimum, possibly longer if they appeal. Are you still committed? I thought about my grandfather bulldozing that road in 1952, my father maintaining it for 30 years, and all the time I'd spent grading and plowing and fixing washouts. I'm committed. Good. Then let's bury them. The legal discovery process was exhausting. I had to provide copies of every document related to the property. Deeds, tax records, maintenance receipts, photographs spanning decades. Martha had me write out a detailed history of the road, including every time I'd plowed it, repaired it, or posted private property signs. The HOA's discovery requests were clearly designed to be burdensome. They wanted 20 years of financial records, all correspondence with the county, detailed maps of the property boundaries, and statements from anyone who had ever used the road. Martha objected to most of it as overly broad and irrelevant, but we still had to comply with the court's modified orders. During this process, something interesting emerged. The developer, Summit Properties, had filed for bankruptcy protection 3 weeks after selling the last lot in Riverbend Acres. The company had multiple lawsuits pending in other Colorado counties for similar issues, selling developments without proper access, misrepresenting HOA authority, and breaching contracts. The owner, a man named Richard Blackwell, had apparently pulled this scam multiple times. Martha pounced on this information. She subpoenaed Summit Properties records related to Riverbend Acres, looking for evidence that they'd knowingly sold properties without legal access. What we found was damning. Internal emails showed that Richard Blackwell's team had identified my road as the only viable access point to the property they wanted to develop. They'd researched the ownership and found my family's deeds. Instead of approaching me to negotiate an easement, they'd made a calculated decision to proceed anyway, gambling that they could either intimidate me into surrendering access after the fact or successfully claim the road was already public. One email from Blackwell to his project manager was particularly shocking. "Don't worry about the access issue. Once we've got 40 families living there, the old guy won't have a choice. Public pressure and legal costs will force him to cave. Worst case, we're already paid and moved on before it becomes our problem." Martha filed an amended response including fraud claims against Summit Properties and Brenda Patterson personally for continuing to pursue claims they knew were fraudulent. The judge ordered expedited discovery on the fraud allegations. Brenda Patterson's deposition was scheduled for a Tuesday in March, 9 months after this whole mess started. Martha invited me to attend and observe. We met at her opposing counsel's office in Denver, a sleek glass tower that screamed expensive lawyers. Brenda arrived looking defensive, flanked by 2 attorneys in matching navy suits. The deposition lasted 6 hours. Martha was relentless, walking Brenda through every claim the HOA had made, every letter they'd sent, every fine they'd assessed. Brenda was forced to admit that she'd never actually seen documentation proving the road was public. She'd relied entirely on assurances from Summit Properties and the HOA's lawyer. "So you authorized thousands of dollars in fines and fees against Mr. Lawson based solely on what a developer told you?" Martha asked. "We had legal counsel review everything," Brenda said stiffly. "But you personally never verified the road's ownership status with the county. That's not my job. That's what we pay lawyers for." Martha slid a document across the table. "Do you recognize this?" Brenda barely glanced at it. "It's the 1891 deed you keep bringing up. Have you read it?" "My lawyers have." "I didn't ask about your lawyers. I asked if you've read it. Have you personally read this deed?" Brenda's face flushed. "No." "So you've never actually reviewed the primary evidence establishing Mr. Lawson's ownership of the road, yet you've continued to assess fines and make public statements claiming the road is public property. Is that correct?" We were acting on legal advice. Martha leaned forward. "Mrs. Patterson, did you know that Summit Properties filed for bankruptcy 3 weeks after the last lot sold in Riverbend Acres?" Brenda's composure cracked. "What? Did you know that the owner, Richard Blackwell, has been sued in 4 other counties for substantially similar schemes?" "I don't." "I wasn't aware." "Did you know that internal emails from Summit Properties show they deliberately proceeded without securing proper access, gambling that they could bully Mr. Lawson into surrendering his property rights after the fact?" Brenda looked at her lawyers, who both looked distinctly uncomfortable. "I want a break." The deposition ended shortly after that. Brenda's lawyers called for a recess and never reconvened. 3 days later, Martha received a settlement offer. The Riverbend Acres HOA would drop all claims against me, remove all liens and fines, publicly acknowledge that the road was private property, and pay $40,000 toward my legal fees. In exchange, I would grant a limited easement allowing residents of Riverbend Acres to use the road for access, subject to conditions. I retained full ownership and maintenance authority. I could revoke access for any individual who violated the terms, and the HOA would pay me $5,000 annually for the privilege. Martha thought it was reasonable. "You win on every substantive issue. They acknowledge your ownership, you get compensated for your legal costs, and you get ongoing payment for the use of your property. The easement protects the residents who didn't create this mess." I thought about it for 2 days. The residents hadn't done anything wrong beyond trusting a crooked developer and an incompetent HOA president. Making them drive an extra 3 miles to reach their homes via the next county road seemed petty. But I also wasn't going to just let the HOA win by settling for less than I deserved. Counter-offer, I told Martha. Everything they proposed, but I want $75,000 for legal fees, and the annual payment is $10,000. And Brenda Patterson has to resign as HOA president and issue a written apology. Martha grinned. Now you're thinking like a lawyer. The negotiation took another 2 weeks, but eventually we settled at $60,000 for legal fees, $7,500 annually, and Brenda's resignation without the apology. I would have liked the apology, but Martha advised that pushing too hard might torpedo the deal. The settlement was finalized in late April. A formal easement was recorded with the county, clearly establishing my ownership while granting conditional access to Riverbend Acres residents. The HOA removed all orange cones, citations, and liens. They issued a letter to all residents explaining the situation and acknowledging that previous statements about road ownership had been incorrect. Brenda Patterson resigned at a contentious HOA meeting where, according to Mark, who called me afterward, she tried to blame the lawyers, the developer, the county, and everyone except herself. The residents weren't buying it. She left to a chorus of boos and was replaced by a retired accountant named Harold Finch, who seemed actually competent. Harold called me a week after taking over. "Mr. Lawson, I want to apologize personally for everything the HOA put you through. I've reviewed the records, and it's clear we were in the wrong from the start. I'd like to establish a better relationship going forward. I appreciated the gesture. I'm willing to work with reasonable people. The easement terms are fair. As long as your residents respect the rules and the HOA makes its annual payments, we won't have problems." "Understood. And thank you for not making this harder than it needed to be. You could have shut us down completely." "I thought about it," I admitted. But the families living there didn't deserve to be punished for Brenda's incompetence and the developer's fraud. Things settled into a new normal over the summer. The residents of Riverbend Acres used the road respectfully. A few of them even waved when they drove past. Tom Henderson's harassment stopped completely, and Harold Finch sent him a formal letter apologizing on behalf of the HOA. But the story wasn't quite over. In August, I got a call from a detective with the La Plata County Sheriff's Department. Detective Sarah Morrison wanted to talk to me about Summit Properties and Richard Blackwell. We met at a coffee shop in Durango. Detective Morrison was in her 40s, sharp-eyed and serious. "Mr. Lawson, we're investigating Richard Blackwell and Summit Properties for fraud, theft by deception, and racketeering. Your case is one of 6 in Colorado where the pattern is identical. Buy land without proper access, develop it anyway, sell lots to unsuspecting buyers, and disappear before the legal problems surface. We believe Blackwell has defrauded investors and home buyers out of millions of dollars. What do you need from me? Your documentation, your testimony, and anything you can provide about the HOA's actions. We're looking at whether Brenda Patterson and others were complicit in the fraud or just negligently incompetent." I provided everything. The emails Martha had subpoenaed, the timeline of events, copies of all the fraudulent citations and liens. Detective Morrison took detailed notes and said I'd likely be called to testify if charges were filed. 3 months later, Richard Blackwell was arrested in Arizona and extradited to Colorado. He was charged with 37 counts of fraud, theft, and racketeering. The district attorney's office also charged 2 of his executives, And surprisingly, the lawyer who had represented both Summit Properties and the Riverbend Acres HOA during my dispute. The lawyer, a man named Gerard Thompson, had apparently knowingly filed false claims about the road's ownership status, despite having access to documentation proving otherwise. Colorado takes attorney ethics seriously, and Gerard was facing both criminal charges and disbarment proceedings. Brenda Patterson was investigated but ultimately not charged. The DA determined that while she'd been negligent and overly aggressive, there wasn't evidence she'd knowingly participated in fraud. She'd been a useful idiot rather than a conspirator. I testified at Richard Blackwell's trial in February, a year and a half after this whole nightmare began. The prosecution walked me through the timeline, had me identify documents and emails, and explain how Blackwell's scheme had affected me personally. Blackwell's lawyer tried to make me look greedy and difficult during cross-examination, but it didn't work. The jury could see the difference between protecting property rights and participating in fraud. Blackwell was convicted on 29 of the 37 counts. He was sentenced to 8 years in prison and ordered to pay restitution to his victims, though most people figured we'd never see that money. His company's assets had been carefully hidden in shell corporations and offshore accounts. The trial made regional news. Several articles revisited my case as an example of Blackwell's pattern of fraud. Jessica Chen from the local paper did a follow-up piece about how the residents of Riverbend Acres were coping with the revelation that their development had been built on fraud. Most of them were philosophical about it. Their homes were worth what they'd paid, and the easement I'd granted solved the immediate access problem. But there was anxiety about whether other issues might surface. Those fears proved justified. In March, an environmental survey revealed that Blackwell had illegally dumped construction waste in a wetland on the development's southern edge. The EPA got involved, and the HOA was facing potential cleanup costs exceeding $200,000. Harold Finch called me to vent about it, and I sympathized. The residents kept getting hit with consequences of Blackwell's shortcuts and fraud. Through all of this, my relationship with Tom Henderson remained steady. We'd started having dinner together once a week, usually at his cabin where he'd cook whatever fish he'd caught recently. Tom had been shaken by the whole experience. "I'm 79 years old," he told me one evening over grilled trout. "I was thinking about selling the cabin, moving into town where it's easier. But that HOA mess made me stubborn. I'll be damned if I let them run me off my own property." "I know the feeling," I said. When Brenda first showed up with those cones, I could have taken their settlement offer and walked away with some money. But it was the principle of the thing. Tom raised his beer. To principles and stubborn old coots who defend them. I clinked my bottle against his. Cheers to that. The annual easement payment from the HOA arrived like clockwork each April. $7,500 for the privilege of using my road. I used the money for maintenance and improvements. Fresh gravel, better drainage, upgraded culverts. The road looked better than it had in 20 years. Harold Finch and I developed a cordial working relationship. When one of the residents started parking an RV on the road in violation of the easement terms, Harold dealt with it immediately. When I needed to close the road for 2 days to install a new culvert, I gave Harold advance notice and he coordinated with the residents. It was almost pleasant, this functional relationship built on mutual respect and clear boundaries. In June, I got a surprise visitor. Ashley, the woman I'd first talked to in Riverbend Acres, knocked on my door with her 2 kids and a plate of homemade cookies. "Mr. Lawson, we wanted to thank you. I know everything that happened was complicated, but you could have made our lives miserable and you didn't. You fought for your rights, but you were fair about it. That means a lot." Her kids, a boy and girl around 8 and 10, nodded seriously. The boy handed me a drawing of my barn with "thank you" written in crayon across the top. I was unexpectedly touched. "You're welcome. And please call me Lucas." Ashley smiled. "Lucas. And I wanted you to know there's been talk in the HOA about doing something for you, maybe naming the road or putting up a plaque or something, to acknowledge what happened and how you handled it." I shook my head. "That's not necessary. The road doesn't need a name and I don't need recognition. The easement agreement and the annual payment are enough. Still, a lot of us know we were on the wrong side of this initially. We believed Brenda's lies. We're sorry about that." After they left, I sat on my porch with the cookies and the crayon drawing, thinking about how complicated human nature can be. These were good people who'd been manipulated by a con artist and failed by their HOA leadership. They'd gotten defensive when confronted with uncomfortable truths, but eventually came around when the evidence became overwhelming. It would have been easy to stay angry at all of them, to nurse grievances and maintain hostility. But what was the point? That summer was peaceful. I worked on the property, fixed things that needed fixing, and enjoyed the Colorado weather. Tom and I took a fishing trip up to Wyoming for a week. The residents of Riverbend Acres went about their lives, and the road served its purpose without drama. In September, I got a letter from the Colorado Bar Association. Gerard Thompson, the lawyer who'd filed fraudulent claims on behalf of the HOA, had been permanently disbarred. The letter thanked me for my testimony in the disciplinary proceedings, and noted that my case had been instrumental in demonstrating Thompson's pattern of unethical conduct. Martha Hendricks called to congratulate me on the disbarment. "That's as close to complete victory as you can get in a legal dispute. Your property rights vindicated, compensation for damages, the fraudsters in prison or disbarred, and you even maintained civil relations with the community. Well done. Couldn't have done it without you," I said honestly. "You believed me from the start and you fought like hell. That's what you pay me for. Plus, I really enjoyed demolishing Brenda Patterson in that deposition. That woman had it coming." We talked for a while about other things, and then Martha mentioned she was retiring at the end of the year. 40 years of practicing law is enough. I'm going to travel and spoil my grandchildren and never think about property disputes again. You've earned it. Thank you for everything. Thank you for trusting me. Your case reminded me why I became a lawyer in the first place. Sometimes you get to fight for something that actually matters and actually win. That's rare. As the year wound down, I found myself reflecting on everything that had happened. 2 years earlier, I'd been living quietly on my property, maintaining my road and bothering nobody. Then Brenda Patterson had shown up with her clipboard, and her orange cones and her absolute certainty that she had the right to take what was mine. I could have surrendered. Many people would have. The pressure was intense, the legal costs were substantial, and the path of least resistance was clear. Accept whatever the HOA offered and move on. But that would have meant betraying my grandfather's legacy, abandoning my property rights, and rewarding fraudulent behavior. Standing firm had been expensive and stressful, but it had been worth it. The law had worked the way it was supposed to work. Clear property rights, documented for over a century, had been upheld. Fraud had been exposed and punished. And in the end, a fair resolution had been reached that protected both my interests and the legitimate needs of the Riverbend Acres residents. I thought my grandfather would have approved. He'd been a man who believed in hard work, honest dealing, and standing your ground when you were in the right. That road he'd bulldozed in 1952 was more than just a strip of gravel connecting the highway to his property. It was a statement about self-reliance and independence. It represented the idea that a man could carve out a piece of the world and defend it against those who would take it without justification. In defending that road, I'd been defending more than just property. I'd been defending the principle that rights mean something, that documentation matters, and that bullies don't get to win just because they're loud and organized on Christmas Eve. Tom and I sat on my porch watching snow fall across the property. The road, my road, stretched out before us, white and peaceful under the winter sky. Smoke rose from chimneys in Riverbend Acres, visible through the trees at the far end of the road. Families were celebrating the holiday in those homes, probably not thinking much about the legal battle that had raged over their access route. "You ever regret how you handled it?" Tom asked. Fighting instead of settling early, I considered the question seriously. No. If I'd rolled over at the first sign of pressure, I'd have spent the rest of my life resenting myself. This way, I can look at that road and know I defended what's mine. And when I'm gone and someone else owns this property, the deeds will be clear and the precedent will be established. Maybe that'll save them some trouble down the line. Tom nodded slowly. Your grandfather would be proud. Hell, I'm proud. Not many people have the backbone to stand up to that kind of pressure. I had good help. Martha, even some of the residents, once they understood what was really happening. It wasn't just me. But you're the one who refused to back down. That was all you. We sat in comfortable silence, watching the snow accumulate. The road would need plowing in the morning, but that was a tomorrow problem. Tonight was for appreciating what we had and what we defended. The legal settlement required the Riverbend Acres HOA to make annual payments for the next 20 years. After that, the terms would be renegotiated or the easement would expire. I'd be in my 70s by then, if I was still around. Maybe I'd be the stubborn old guy refusing to let the HOA push me around. Or maybe I'd be gone and it would be someone else's fight. Either way, the documentation was clear. The 1891 deed, my grandfather's purchase in 1952, the continuous chain of private ownership, all of it properly recorded and legally bulletproof. Future property owners would know exactly what they were getting and what rights they held. That was worth fighting for. That was worth the stress, the expense, and the conflict. Because property rights only matter if people are willing to defend them when they're challenged. Harold Finch sent me a Christmas card that year. It was a generic winter scene with a handwritten note inside. Thank you for your patience and fairness in resolving our difficulties. Wishing you a peaceful holiday season. Harold. I appreciated the gesture. Harold was proving to be a competent HOA president, focused on actual community needs rather than power games and harassment. The contrast with Brenda Patterson was stark. I wondered sometimes what had happened to Brenda after her resignation. I'd heard she moved out of Riverbend Acres, unable to face the neighbors she'd embarrassed with her incompetence. Part of me felt bad for her. She'd been in over her head, manipulated by a con artist, and left holding the bag when it all fell apart. But another part of me remembered her arrogance, her threats, her absolute conviction that she had the right to dictate terms on my private property. Some lessons are learned the hard way. The new year brought fresh snow and clear skies. I plowed the road on January 2nd, my truck rumbling through the pre-dawn darkness, blades scraping gravel as I pushed snow into neat berms on either side. It was hard work, physical work, the kind that left you tired and satisfied at the end. As I passed the turnoff to Riverbend Acres, I saw lights on in several houses. People getting ready for work, making breakfast, starting their days. They'd use my road to leave and come home, probably without giving it much thought. That was fine. The easement was working as intended. Back at my barn, I parked the truck and sat for a moment, watching the sun come up over the mountains. The property looked beautiful in the winter light, the barn and house and fields all touched with gold. My grandfather had chosen this land well. It was worth every fight to keep it. I went inside, made coffee, and pulled out the crayon drawing the kids had given me. I'd kept it on my refrigerator, a reminder that most people are decent when given the chance. The HOA mess had brought out the worst in some people and the best in others. In the end, the best had won out. That felt like the right way to close this chapter. The road was mine, legally and practically. The community had access on fair terms. The fraudsters were in prison or disbarred, and I could sit on my porch, drink my coffee, and know that I'd stood my ground when it mattered. My phone rang around noon. It was Detective Morrison from the Sheriff's Department. "Mr. Lawson, I wanted to give you an update. Richard Blackwell's restitution hearing was yesterday. The judge ordered him to pay back everything he stole, about $4.2 million across all his victims. Will anyone actually see that money? Probably not much of it. But we did find some assets, and you're on the list for partial restitution. You should see about $15,000 eventually. Better than nothing. Definitely. And I wanted to thank you again for your testimony. Your case was key to establishing the pattern of fraud. The jury really responded to your story." After we hung up, I sat thinking about those $15,000. I hadn't expected to see any restitution, so it was a pleasant surprise. Maybe I'd put it toward a new truck. Mine was getting old and the transmission was starting to slip. Or maybe I'd use it to improve the road even more. New gravel, better culverts, maybe even some proper shoulders. The easement payments covered basic maintenance, but there was always room for improvement. Tom came by that afternoon with a bottle of whiskey to celebrate the restitution news. We sat in my living room, the fire crackling, and toasted to justice delayed but not denied. "You know what the best part of all this is?" Tom said, slightly buzzed. "You didn't just win. You made them admit they were wrong. That's rare, Lucas. Usually these things settle with nobody admitting anything. But you got them to acknowledge the truth." He was right. The settlement agreement explicitly stated that the Riverbend Acres HOA acknowledged my ownership of the road and withdrew all previous claims to the contrary. That public acknowledgement had been important to me, maybe more important than the money. "It matters," I agreed. "Truth matters, facts matter. You can't just make up reality to suit your purposes. Try telling that to most people these days." We talked late into the night, solving the world's problems the way old friends do over whiskey. By the time Tom left, both of us were feeling philosophical and slightly drunk, satisfied with our small victory against entropy and human stupidity. The next few months passed quietly. Spring came to Colorado with muddy roads and budding trees. I spent my days working on the property, fixing winter damage, and preparing for summer. The easement payment arrived in April, right on schedule. I deposited it and bought the gravel I'd been planning. In May, Harold Finch called with an unusual request. "Lucas, we're having our annual HOA meeting next week, and I'd like to invite you to speak. Not about the legal issues, but just to introduce yourself properly to the community. A lot of residents have never actually met you, and I think it would help everyone to put a face to the name." I was skeptical. "I don't know, Harold. I'm not much for public speaking. Nothing formal. Just come by, say hello, maybe answer some questions." I think it would go a long way toward building goodwill. I agreed reluctantly. The following Tuesday, I drove to the Riverbend Acres Community Center, a building I'd never been inside before. About 40 people were there, sitting on folding chairs and drinking coffee from a large urn. Harold introduced me warmly, thanking me for coming and briefly recapping the resolution of the road dispute without dwelling on the uglier details. Then he invited me to say a few words. I stood up, suddenly nervous. "Hi, I'm Lucas Lawson. I've owned the property at the end of your access road for about 30 years. My family's owned it since 1952. I know we got off to a rough start with the road situation, but I'm glad we were able to work out a fair solution. I appreciate that most of you are respectful of the easement terms. If you ever have concerns or questions, Harold has my number. That's about all I've got to say." There was polite applause. Then a man in the back raised his hand. "Mr. Lawson, why didn't you just take the money initially when the HOA offered to settle? Wouldn't that have been easier?" I thought about how to answer honestly without being offensive. It wasn't about money. It was about principle and property rights. My grandfather built that road 70 years ago. My family has maintained it ever since. When someone shows up and tries to take that away based on false claims, you don't just roll over. You fight back. But once the facts were clear and fair terms were offered, I was willing to compromise. A woman in her 60s spoke up. "I want to apologize. I was one of the people who believed Brenda when she said you were just being greedy. I feel terrible about that now." "Don't feel terrible. You didn't have all the information. That's why documentation matters and why legal processes exist, to get to the truth." More questions followed, mostly friendly and curious. What was the property like back in the 50s? Did I ever think about selling? What kind of maintenance did the road require? I answered as best I could, and by the end, the atmosphere was genuinely warm. Ashley came up afterward with her husband, a tall guy with a firm handshake. "Thank you for coming, Lucas. This really helps. A lot of people were nervous about you, worried you'd shut down access or make trouble. Meeting you face to face changes that." "I'm not interested in making trouble," I said. "I just want to live on my property in peace and have my rights respected, same as everyone." Driving home that night, I felt like something had shifted. The conflict was truly over, replaced by a functional relationship built on mutual understanding. It had taken 2 years, but we'd gotten there. The summer was busy with property maintenance and several fishing trips with Tom. In August, he had a health scare that put him in the hospital for a week. I visited daily, bringing books and bad jokes. When he was released, I helped him get settled back in his cabin. "I'm getting old, Lucas," he said quietly, "starting to think about what comes next. You've got years left in you. Maybe, but I've been thinking about the cabin, what happens to it when I'm gone. My daughter lives in Oregon and has no interest in Colorado. She'll probably just sell it. That's her decision to make. I know. But I'd hate to see it go to some developer who'd tear it down and put up a McMansion. This place has history." I understood the feeling. "Put it in your will that you want it sold to someone who'll preserve it, or maybe donate it to a land trust." Tom nodded slowly. "Those are good options. I'll talk to a lawyer." The conversation stayed with me. We all get old. Properties outlive us. The best we can do is pass them on responsibly and hope the next stewards appreciate what they're getting. In September, I got a letter from the county. They were updating property records and needed me to verify my boundary information. I pulled out my documentation, confirmed everything, and sent it back. The process reminded me again how important proper record keeping is. Without those deeds and that chain of ownership, my fight with the HOA would have been much harder. October brought the first snow, early even for Colorado. I plowed the road twice in 1 week, rumbling back and forth in the pre-dawn darkness. The physical work felt good, purposeful. This was my road, my responsibility, my legacy. Harold called in November with surprising news. Lucas, the HOA voted to put up a historical marker at the entrance to the road, not to honor you specifically, just to acknowledge the history. Something like private road ESD. 1952, easement granted 2024. We wanted to run it by you first. I thought about it. I appreciate the gesture. Yes, that's fine, as long as it's accurate and doesn't imply public ownership. Absolutely. We'll send you the exact wording before we install anything. The marker went up in December, a tasteful bronze plaque on a stone base. It read, Whitman Road. Private road established 1952 by Lawrence Whitman. Maintained by property owner. Easement access granted to Riverbend Acres 2024. I liked it. Simple, accurate, and acknowledging the truth. Tom came over to see it and we took a picture together. Two old guys standing next to a bronze plaque on a cold December day. Your grandfather would approve, Tom said. I think so too. As the year ended, I found myself at peace with everything that had happened. The fight had been necessary. The resolution had been fair. And the road my grandfather built was secure for at least another generation. On New Year's Eve, Tom and I sat on my porch again, bundled against the cold, watching fireworks from Riverbend Acres light up the sky. The community was celebrating, unaware or unconcerned about the legal battle that had secured their access. To another year, Tom said, raising his glass. To another year, I agreed, and to standing your ground when it matters. We clinked glasses and drank. Two stubborn men who'd refused to be pushed around, sitting on private property that would remain private because we'd had the courage to fight for it. The road stretched out before us, snow-covered and peaceful, a monument to principle and perseverance. And that, I thought, was exactly how it should be.